The fact that it is followed by a majority of people cannot be validated by the Constitution. And also, Act 25 guarantees the person under the following exceptions alone to proliferate any religion of choice: public order, health, morality. Other provisions of Part 3. Does Shariat Act give applicability to triple talaq? According to Muslim law, the Muslim man under the circumstance like the woman is indocile or with a bad character alone can divorce his wife, otherwise he can't. The answer to the question, it will come under Art 13.1, pre-constitutional law, because it came before the commencement of the Constitution in 1937. According to pre-constitutional law, if anything infringes fundamental rights, then that should be declared as void according to their inconsistency level by using the doctrine of eclipse and severability. Triple talaq is violative of Art 14 because it gave privileges to males alone and not females, and according to Art 13.1, Shariat Act, as far as giving applicability to triple talaq, should be struck down. This is the applicability of triple talaq in Shariat Act disposition. The case is disposed of accordingly by a 3.2 majority. The Constitutional Bench of the Apex Court held that triple talaq is a non-constitutional practice on 22 August 2017. The judgment was reserved for this case after an argument that went on for about 6 days. Parliament was directed by the court to bring legislative measures against the practice of triple talaq. Muslim personal law regulated talaq-e-biddat, which is the holding position of J. Rohinton Nariman, Uday Umesh Lalit. Because of the arbitrariness, they held triple talaq as unconstitutional in its nature. The concurring opinion was given by J. Kurian Joseph, in which he held that due to the arbitrariness of triple talaq against the holy Quranic principle, it lacked legal sanctity. The dissenting heretic opinion was given by C.J.I. Kahar and Abdul Nazir, in which they elevated the personal law into fundamental rights in the debate of Constituent Assembly on Art 25 and Art 44. They made a statement where they held that triple talaq is protected under Art 25. Why? Because even though it is not regulated by the Shariat Act, still it is an intrinsic part of personal law, and they made a statement stating that we cannot challenge its constitutionality just because of the fact that it provided a solution to gender discriminatory the cases. We will think that the correct one to take is the court's decision, and the same also can be used as precedent in many cases. But this case made a different approach because the principles which were given by the majority judges give rise to a new debate called, in a secularized country like India, how to look at personal law. The major arguments which were raised to JKR were that scope of the sovereign law does not include an uncodified law of personal law to be enacted and authorized by the state, and also the general principle is only state-enacted laws are subjected to fundamental rights, and here it is not similar to the general principle. For this, he gave a varied opinion to the Constitution, and the same was held valid to J. Nariman's decision made a different view that he included triple talaq under Art 13. Law in force. Analyzing the violation of Article 14J, Nariman made the test of arbitrariness void. But the general principle is Art 14's violation can be found through the test of reasonable classification as well as the test of arbitrariness. He finally reached the conclusion where he focuses on the arbitrariness of the religious practice of triple talaq, rather on the inequality of the two genders, analyzing the right to gender equality under Art 14 and Art 15. They formed more towards un-Islamic practice, rather than on the ill effects of triple talaq. It will follow the same result of the Shayara Bano case if AIMPLB views it as a problem of Muslim identity. Nothing happened like in the judgment of the Shayara Bano case, and they gave a judgment that is similar to equality, where marriage had been given a higher priority as an institution. Analyzing the right to freedom of religion, J. Nariman made an argument by saying that it was not protected under Art 25. J. Joseph also came with a similar opinion, but moved the case in a quite different manner by saying that it is the judge's duty to decide on the case and clearly explain where private law is unclear about something. His only focus was to determine the legal sanctity of triple talaq in Muslim personal law, rather than to choose the constitutional aspect. He tactfully invalidates instantaneous triple talaq by mainly focusing